everyone. Welcome to the Children's Policy Centre webinar series. I'd like to begin by acknowledging the Ngunnawal and Ngambri people on whose land on which I am broadcasting from today, and pay my respects to their elders past, present and emerging, and who have never ceded sovereignty and remain strong in their enduring connection to land and culture. My name is Angie Bexley. I'm Deputy Director of the Children's Policy Centre, which is based here at the Crawford School of Public Policy at the Australian National University. And with Director Professor Sharon, the Children's Policy Centre undertakes innovative and interdisciplinary research on a range of issues relating to children's policy. We seek to connect researchers, policymakers and practitioners working on a range of issues to promote the human rights, wellbeing and best interests of children. And we aim to communicate the findings of our research and that of others with those who matter. In observance of tomorrow being World Children's Day, this is the first in our series of webinars marking 30 years since Australia ratified the Convention on the Rights of the Child. This webinar series will bring together the researchers and advocates to ask how far we have come and how far we have to go in securing the human rights of children in Australia. Over the coming weeks, in fact, each Thursday at 1 p.m, same time, same place, we have a fabulous lineup of speakers who will be covering issues, for example, on the age of criminal responsibility and the UNCRC and child protection in Australia. So we look forward to your participation in these webinars as well, and they're all posted on our website where you registered today. The Convention on the Rights of the Child is the most extensive and widely ratified human rights convention in history. Every 5 years, the Australian government reports to the United Nations Committee on the Rights of the Child, and its last appearance was in September last year. The guiding principles of the convention are non-discrimination, best interests of the child, the right to survival and development, and the views of the child. We are delighted to have with us here today Professor John Tobin from the Melbourne Law School, who is going to bring to life for us some of these issues in the context of Australia. John brings a wealth of knowledge and experience to the issues of human rights and children's rights in the context of the law. He has held a number of distinguished appointments in Australia and overseas and has been recognised for his excellence in teaching. John is currently the Francine V. McNiff Professor in Human Rights Law and Co-Director of Studies in Human Rights Law. In 2012, John received an ARC Discovery Grant with Professor Philip Alston titled Children's Rights from Theory to Practice, which produced a comprehensive commentary on the Convention on the Rights of the Child. John has also initiated the Children's Rights Academic Network, and we encourage you to get in touch with John if you wanted to find out more and join this network. The topic of today's talk is called Protecting Children's Rights. Are we there yet? John will speak for around 40 minutes or so, and if you have questions, please put them in the chat and we can address these at the end. Over to you, John.
Fantastic. Can everyone hear me okay, hopefully? Thumbs up. So thank you, Angie, for that very kind of introduction as well, and thanks, Sharon, for inviting me part of this proceedings. I'm just going to share my screen here, so give me one moment to bring up the slides. Okay, I'm hoping you can all see that and it's all nice and clear. So I also want to start by acknowledging that I'm actually sitting in Melbourne at my desk at my home, living on the lands of the Wurundjeri people. It's actually very warm down here, so apologies to the fans being in the background as well. Pay my respect to their elders past, present and emerging. Also, I'd like to acknowledge the impact of dispossession and colonisation on Aboriginal people and the enduring impact, particularly on those removed from their parents and the stolen generation. And I suppose to acknowledge in a context like this, that if you're a young Indigenous child, you're more likely to be placed into detention in the criminal justice system, more likely to be placed out of care and suffer disadvantage in terms of access to education, healthcare and housing as well. So in terms of closing the gap, we've got a long way to go as well. I think it's important in a series like this to acknowledge that as we begin. So in terms of what I want to start with, we've got 40 minutes of talking. I could speak a long time on this topic, having worked in this area for some 20 years or so now. But I'd like you all to be thinking about how far you've come personally in this understanding of what it means to think about children as rights bearers as well. So if we're in class, I'll be asking you to raise your hand, but of course we can't do that now. But you can, of course, put your comments in the chat if you wanted to as well. But I want you to think about the first two words that come into your mind when asked to describe children. Don't think about it, just an intuitive response, what those first two words might be. Why is it important? Because I think it gets us a sense of how we as adults think about young people, and then the consequences of that thinking on how we go about dealing with issues that concern them as well. So hopefully you've had a chance to actually undertake this, and I think it's a really important reflective exercise. As someone with 4 children, I find myself often defaulting to visions of children that don't align with the rights-based approach. Can't help that. 50-year-old, male, heterosexual, privileged adults, educated in ways that aren't as probably progressive as they should have been when I was at school, Christian brothers. So there are things that are embedded in my mind that need to be shifted and changed as well. So going to the next slide, this is when you start assessing, I suppose, where you sit yourselves in terms of the values you might have identified. And I want to make sure there's nothing wrong with these answers, but I think it's important to identify where we might sit and then be asking ourselves more generally, where do our policymakers, our legislators, our regulators also sit with respect to these issues as well? So if we ask this question in a broader community, what that answer might be as well. So issues around vulnerability, protection, the future are the sort of words that commonly are used in response to the question I've just posed. And again, all those things aren't actually necessarily wrong per se, but from my mind, they're only part of the story. Okay, so we're thinking about the idea of rights and how we come understanding children as rights bearers. We want to see a shift from that welfare-based approach with the deficits of children to a rights-based approach which recognises their strengths as well. So this is a very personal, obviously, response, but I think it's really important as well. And my argument, I think, right now would be that after some 30 years, we are making progress towards that column with strengths being recognised, but we're still some way from being there. And the dominant approach informing most of our policy when it comes to issues around children, in fact, is what I use or refer to as a welfare-based approach. And ask yourselves, when you're thinking about any of our policymakers, our legislators, again, the language they use to describe children, the word rights is seldom used. That could be for strategic reasons, but often it reflects a deeper commitment to the idea of children not as rights bearers, but as children in need of protection, as being vulnerable, and as adults having a responsibility to protect them. That's part of the story, but only part of the story. So our rights-based approach requires a bigger shift. We're not quite there yet, but that's, I think, part of the journey. So moving forward then in the space of time I've got. Next question, and so let's go to the sort of legal part question, or that sort of inquiry that entertains people like me with my writing. So when we protect not children's, but children's rights, how far have we come? A few resources to consider to get a much more detailed response to this question. First is the Children's Report by the Australian Child Rights Task Force, a really, I think, thoughtful and collaborative NGO grouping that's really done some amazing work in trying to detail and capture what's actually happening in respect of children's rights. The second is the most recent and the last report of Megan Mitchell as Commissioner for Children and Young People in Australia, which details, I think, a really great coverage of all the issues confronting children, and of course the most recent committee's report from last year as well. So they're all resources I encourage you to read in your own time. We won't explore this in detail today, but they're, I think, really important starting points. Where do we go to next? I think it's important that when I ask the question, how far have we come, or how far do we have to go, the answers vary greatly. Okay, so the quote at the bottom of the screen you'll see here is from the federal government. No surprises here. So when they reported to the committee in 2018, the report, again, no surprises, was very confident and somewhat proud of the achievements that have been made in furthering the rights of children, allocating resources to ensuring that children reach their full potential and realise their rights under both the convention and its optional protocols. Of course, as you know, that's politically informed, but I think there'd be some that would think that if we are allocating resources to assist children, then we are protecting their rights. Of course, the reality is it's much more complex than that. And so the quote above is actually taken from the Australian Child Rights Task Force report to the committee, and it captures one of the views of young people themselves. And you'll see here quite clearly that their view is very different. Australia's failing its children, we don't know our rights, and we're not taken seriously. So in some ways, this entire topic is we asking the wrong person for the answer to the question. I, as a privileged white male, am doing pretty well for myself in the current circumstances, but young people have a very different view about how their rights and the extent to which the convention has been realised as well. So just moving forward then, what do other young people tell us? And I just want to highlight that the research taken by Megan Mitchell again is really, I think, instructive in this regard. So one of the things she did was to set out to actually gather data from children themselves as to how they saw their rights being protected or not as well. And that involved a number focus groups with children across the country of various age groups, from young primary school right through to older adolescents as well. And what you'll see in the responses that they provided, of course, are some of these really important findings. These things that most ring true for children: breathing clean air, drinking water, okay, can be cared for, can get an education. Of course, not all children can, but those are the ones that most ring true. Most important, feeling safe, being cared for. And I think the ones that least ring true, I think, are really significant for us as adults. I can have a say about things that are important to me, I'm treated fairly, and I can get accurate information when I need to. So young people are telling us themselves that one of the key elements of the convention, Article 12, as I'm sure you're all well aware of, is not being realised and secured for them. Okay, so in that sense alone, we've got somewhere to go. As I'll show towards the back end of the presentation, we're making contributions and we're making steps forward in seeking the views of children. But of course, voice is not enough, as my colleague Laura Lundy would say. We need to do more than that. But clearly, young people themselves are recognising deficiencies in the way in which we're creating systems to enable them to be heard in things that affect them as well. So again, if you get a chance to read the report, I'm obviously editing much of its content, but I think it contains some really useful insights as well.
John, sorry to jump in here. We're just not seeing your slides. Would you be able to click through to where you're
I'll share again. Is it coming back up now?
That's it. Thank you.
Okay. So did we miss that last slide?
Yes.
Okay. So, okay. Can it's not okay now? Thumbs up if you've got it. Yeah, okay, great. Or chat, use the chat function, of course, as well. So just summarising here, rights that ring at least true are those ones around children's capacity to have a say in things that affect them, and basic issues around being treated fairly. And that can be in any context, youth justice, child protection, the schoolyard, a sporting team. Certainly in my experience, it occurs across all those areas where young people are involved and engaged. And then more broadly, just being aware that, of course, when it comes to our standing and status internationally, I'm hoping you've all seen or had a chance to read this. It's UNICEF's most recent report about the experience of children's well-being in developing countries, and you'll see we rank a lowly 32nd. Okay, so, how far have we come? We've got a long way to go, I think. And I've listed the top 10 there, okay? We're some distance from them in terms of how we might achieve a much higher ability to achieve the well-being for young people in this country as well. So what do I want to do now? So being a lawyer by profession, and most of my research focuses on how we think about the systems and structures we create to protect children's rights. I want to spend some time, if I can, talking about the existing governance structure in Australia for the protection of rights. Many of you will have different perspectives, which is a really important part of the conversation, so we can bring those into the conversation at the end. But I'd like to sort of just outline some of these structures, because I think they're really important, because they set, I suppose, the framework around which we can protect rights. Now, when we think about at the federal level, as we all know, there's no Bill of Rights. I know today the Law Council of Australia is now promoting the idea of a National Charter of Rights, and there's an ongoing NGO campaign to achieve that end as well. I don't think it's likely to be achieved in the short term, but it's certainly happening. But there is no, as I said, federal system to protect human rights. There is, however, a couple of things I just want to flag. We do have the parliamentary human rights scrutiny legislation that does create a committee to scrutinise federal legislation, and doesn't require all ministers to ensure that when they introduce legislation into that House, that it is scrutinised against all human rights, including the Convention on the Rights of the Child. So in some ways, we have this system whereby we're meant to have this pre-legislative scrutiny of all legislation against the standards in the Convention on the Rights of the Child. Now, some of you probably know that that is often in a very cursory way. And you wouldn't say it provides effective protection of children's rights. There's potential to expand that, no question at all, but the current climate is that there's not a great appetite for engagement with detailed, rigorous assessment of legislative proposals by reference to the Convention on the Rights of the Child. There is, of course, the committee, and the committee has regularly commented on issues that concern children, whether it's around welfare payments, treatment of refugees, stripping citizenship for young people. So the committee itself is always making recommendations to the government, but again, the appetite for rights protection generally in Australia, let alone children's rights protection, is very weak. So that federal system isn't as effective as we'd like it to be. Hence, you're seeing these calls now from the Law Council and NGOs for a much more effective National Charter of Rights. And there's a conversation there for us to think about, well, where the rights of children fit within that proposed National Charter as well. That then takes me to the state level. And as we should all hopefully know, there are now 3 jurisdictions with some kind of legislative protection for rights: Queensland, the ACT, where my colleagues are residing as we speak, and of course also Victoria. But if you look at those charters closely, the protection of children's rights is very, very minimal. Okay, there are some protections around juvenile justice, a right to education, included now up in both the ACT and Queensland, right to health, but there isn't any general commitment, again, to engage with issues concerning children's rights, as we'd expect under the Convention on the Rights of the Child. There's been reviews of those systems, particularly in Victoria, but each time a review takes place, my reading of that conversation is that children's rights become less and less of a consideration for formal inclusion within the Victorian Charter. So in some ways, we haven't really developed where we'd hope we might have developed from 2006, particularly in Victoria, around protection of children's rights. And that hasn't obviously happened in Queensland either, which mirrors their model on what's happened in Victoria and also the ACT. So our legislative structure is very weak when it comes to protection of children's rights and of course human rights as well. I'll come back to that later on. So where have we seen some progress? Well, we have seen some progress in the areas I've outlined below, okay? Courts have struggled because of the absence of an explicit legislative framework, for sure, but you do see judges in various jurisdictions trying to draw issues from the convention and the idea of children's rights into conversations in their courtrooms. They're not in a majority, very much a minority, but opportunities do present themselves. The family court, for example, in some of the gender dysphoria cases, has drawn upon issues under the convention to inform the way in which it conceptualises children, issues around capacity, right to be involved in decision making. So there's some conversations happening there. And even in Victoria, we've had some protocols adopted with respect to treatment of young people in the Supreme Court. But again, the role of the courts is very much limited because of the absence of a strong regulatory framework in legislation as well. Institutions, I think we've seen some significant developments on one front, but less on a second. The first front, of course, is the establishment of commissioners for children in states, territories, and also federally as well. So when I started working in this area, there was one commissioner, which was in Queensland, okay? Now we have them in every state and territory, and we also have a federal commissioner as well. So that's a significant achievement to actually get that institutional presence where those individuals have a mandate to actually advocate for children's rights. But I don't want to overstate the significance at the same time, because if you look at the legislative mandate for many of those professionals or those commissioners, it's tied to issues often around child protection. So it's not a mandate writ large to protect the rights under the convention. Certainly many commissioners will adopt that in the way they go about their work, but that creates a real tension for them about making sure they don't overstep their mandate as well. The only person who has the broadest mandate to consider children's rights, of course, is the Federal Commissioner, was Megan Mitchell, now Anne Hollands, and their role clearly is to try and promote awareness of the Convention at the federal level, but also across Australia at every level in government as well. But the challenge they face is one person with limited resources and limited staff has a very, very large role to play. But certainly you can't underestimate the role that those institutional bodies play. The second institutional framework I just want to refer to, of course, is having dedicated ministers. Okay, so federally we've got a assistant minister for children and families, but if you look at the work of that minister, there's not a great deal of engagement with the idea of human rights. Certainly the Committee on the Rights of the Child has urged the government to sort of properly resource and equip that ministerial portfolio with a much greater mandate to think about children's rights. But as we presently sit, it's more, in my mind, located around welfare considerations than the broader rights-based framework that I'd like to see them adopt as well. So as I said, significant progress around commissions for children and young people, but still some way to go in terms of ministers and their mandates, and also the actual mandates of those commissioners as well. The next area is around policy frameworks and plans of action. And I think this is where you see a lot of reference to children's rights emerging, far more than was the case when I started in this area 20 years ago. I think for most of the 1990s, children's rights were largely invisible, which I'll explain reasons for in a moment. But in the last 15, 20 years, it will be hard pressed to see a policy development that does not include some reference to the convention, okay? So whether that's around trafficking of children, youth justice, whether it's around adoption, same-sex marriage, it includes protecting children more generally, we're seeing constant references now to the convention, and often as a way of framing and guiding the actual content of those particular frameworks as well. Early childhood's a very good example of that, where you see both the professional bodies and also practitioners trying to engage in a serious way with the convention as a tool to deliver services for children in early childhood and education. And it varies, of course, across the sectors as well. But there's no question we're seeing the convention have a greater role to play there. I'll have to discuss it later on. And then inquiries, of course, of which there have been far too many, but perhaps it's a good thing in that we're seeing into investigation into what's happening that's wrong for children. But of course, troubling that so many issues are occurring. So the Royal Commission on Institutional Child Sexual Abuse clearly considered the convention, as did the Royal Commission on Juvenile Justice or Youth Justice in the Northern Territory as well. Then more locally, we've got inquiries in Victoria around domestic and family violence, and of course the Australian Human Rights Commission inquiries around refugee children. Most of those inquiries, generally but not always, are using the convention and the idea of children as rights bearers to inform the way they go about undertaking their inquiry, and also the way in which they outline their recommendations and their reviews as well. So keep moving on then. What I want to do is just, this is one example, protecting children is everyone's business. Now we're about to start redrafting the next framework protecting Australia's children. Keep in mind, there is no national plan of action to protect children's rights in this country right now, which is a mission, of course. But I suppose a challenge moving forward for someone like Anne Hollands and all of us who've got interest in this area is to say, well, how could the convention play a role in better informing this particular framework? One of the questions I'd be asking about this particular framework is that the references to the convention are largely incidental. Okay, so it appears on page 1 or 2, but beyond that, you don't really see anything about the Convention on the Rights of the Child in its detail, nor the work of the committee on issues around violence and protecting children against harm as well. So we'll come back to that too. So that's just one example. Okay, but I do want to flag, there is no doubt in my mind a shift, and particularly around the idea of how we think about young people. And right now in Victoria, we're developing a youth strategy. For me, the very strange age of 12 to 25, a 12-year-old, and my twins turned 12 today, are very different to the 25-year-olds that I teach at Melbourne University. So question about whether that's the right sort of age range, but in any event, there's no question that the government's seeking to get the views of young people to inform that approach. And you'll see on the other side here, there's just great conversations being taken amongst academics around the way in which we start to embed children's views into the way we develop things, including things around urban planning as well. So I think there's certainly a shift. We're not there yet, but the shift is taking place as well. So what I want to really, I suppose, perhaps focus on now is this idea about how we critique what's happening with a view to trying to improve the quality of the outcomes. So you've seen the slide there, hopefully, Hart's letter of participation, which is sort of very iconic in anyone who's done anything around children's participation, children's rights. I mean, I think everyone would have done, you know, looked at Hart's letter, drafted back in 1992, I think it was actually adopted and modified since then. But this idea that when we talk about child rights-based approaches, it's not just about that manipulation, decoration, tokenistic reference to children who become, you know, the kids who open the conference or the workshop and they do a dance or we see their pictures. But in fact, we get to the point where young people are actually collaborating with adults to create policies and outcomes and processes that are relevant to them as well. So it's much more child-centered and much more child-directed as well. So in some ways, what I want to be thinking about in my work, and certainly encourage others to think about, is, well, how do we create a similar hierarchy by which we can critique the way in which we are seeing policymakers, judges, regulators, service providers actually engage with the idea of children's rights, okay? So you'll see here, I couldn't draw a ladder, my apologies, my skills aren't as good as they should be on the IT. In fact, it's an upside down ladder in many respects, because I've got a ladder which sort of goes through stages from the invisible to the substantive. Okay, so the invisible, of course, is a policy initiative, idea, law that just makes no reference to children at all. They're not, or children's rights are, they're not even acknowledged at all. So, you know, a good example would be a federal budget. Okay, it just doesn't include any reference to the idea of children as rights bearers. It may allocate some awareness to children and what they get in terms of education and health, but it's not what we call a child rights impact assessment. We're not looking at what we think in terms of budgetary analysis from a human rights perspective. It's largely invisible as well. Okay, and there are many examples of that happening, and often those examples happen in areas that are beyond, you know, the legal area. For example, last year we had a coalition on health professionals adopt a consensus statement on childhood obesity. A great statement, but no reference to children's rights at all. Now, question, does it matter? I think it's a really important question to make. I'd say rights are important when addressing issues around children's health and issues around obesity. But of course, in some disciplines, health is not rights is not a priority. It's not the focus of the conversation as well. So you can get a sense, you're going to be able to be critical here. Sometimes we want to be careful that rights aren't seeking to dictate or colonize competing agendas for transformation in children's lives. But I do think we need to be thinking about, if it's absent, what role should rights be playing in those conversations as well. There was a Royal Commission on Family Violence in Victoria in 2016. You know, I didn't see much reference, if any at all, to the idea of children's rights bearers. I didn't see any reference to the idea we might start actually putting a prohibition on the practice of corporal punishment, which you think might in fact be what you want to do if we're talking about family violence. Let's start with the act that I can actually physically abuse my children every day of the week, provided it's reasonable. If you want to stamp out family violence, maybe we should start with the idea that children shouldn't be subject to assault, and that should be sanctioned by the law. So invisibility is common. The challenge for us becomes, well, how do we respond to that? Then moving down, incidental becomes still common in terms of there's a reference to children's rights perhaps through submissions, but that plays no role or part in the actual resolution of the issues before the inquiry or the regulator or the service provider as well. So a good example of that would be the inquiry held by the Senate around lowering the voting age. Worth reading if you get a chance, the final report of that, because you see people making submissions around the role and relevance of the Convention on the Rights of the Child, the importance of children's views. At the end of the day, the inquiry just says, we're not convinced that it's warranted that we lower the age of voting, full stop. There's a reference to the convention there, but it's not engaged with it in any substantial way at all. Selective or perhaps misappropriation is common, but thankfully a bit less common now. That's when we see advocates or policymakers or legislators actually using convention in a selective way to defend a particular practice, which is actually not consistent with the convention. So two examples would be refugee children and separation from their parents. The government says, we've got to detain them because we can't separate them because Article 9 says you can't separate children from their parents. Clearly wrong response because you shouldn't be detaining both parent and child, but that's how it's misappropriated. The other one is around issues concerning same-sex adoption or same-sex marriage, where we saw conservative groups appropriating the right to know and be cared for by parents to argue that provided a right to have opposite sex parents, a father and a mother, which of course is not consistent with a broader reading of the convention, but it was used as a misappropriation of rights language to advance that conservative agenda. So selective is out there. It's about us and critiquing and drawing to attention the misuse of rights language to actually agitate for causes which aren't consistent with the Convention on the Rights of the Child. So rhetorical or superficial, that's where most of the analysis takes place from my mind. So you see some references to the convention. It might be listed as being a core principle, but in fact, the convention itself, the work of the committee, the commentary from academics who work in this space has little or no role at all to play in how the issues are conceptualized and how the problem is actually addressed. So, to go back to the national framework, as I said, the principal aims or the goals are supposed to be informed by the Convention on the Rights of the Child, but there's little, if no, substantive analysis of what that actually requires in terms of, well, what obligations do states have, what measures are they supposed to take, what might the Committee's general comments on protection against violence tell us and direct us with respect to measures that are required of states to actually protect children. So this, I think, is a really common issue. And part of that, of course, as well, is often seen in the way in which we use children's voice. Okay, so to echo Laura Lundy's voice is not enough. It's not enough to say, oh, we spoke to a few kids about this issue. That's not a rights-based approach. That's part of what you're required to do, but that engagement with young people much more substantive and must be fully informed, and then that information must be used in a way which is consistent with the other principles that inform the convention as well. So, that's where I think we need to be adding much more value to demonstrating the relevance, the utility, and the capacity of a substantive rights-based approach to actually provide much greater guidance. And that's what takes me to that last sort of, I suppose, the ideal standard. What does substantive rights-based approach look like? And it sort of takes us right back to the start of this conversation, and how do we think about how do we see a child? If we see a child as being dependent, vulnerable, the future, with no competency, no experience, no expertise, then we're already adopting a welfare-based approach, okay? We're not even recognising the capacity to have rights or what those rights might be. Under a rights-based model, we've got to start saying, hey, hang on a second, what's happening to that young person now is actually interfering with their rights. And once we start saying that has, I suppose, consequences about then the obligations of the state to actually protect, fulfill, or respect that right, okay? And then it has consequences how we go about developing the response to address that issue. So the procedures, the policies we develop, particularly with respect to the way in which we engage with young people, the methods you might use to actually have them as part of the process to develop a solution if it's age appropriate. But of course, there's more. And you want to start saying, well, once you've identified the issues, once you've developed the policies, what are the actual rights in question? What do they actually mean in terms of what are the entitlements of the young people? And then what are the obligations of the state to actually address those particular potential interferences, and what are the obligations of the state to regulate, for example, the behaviour of third state actors, parents, corporations, schools, etc. as well. Human rights law gives us an answer to those questions, but they're often not used as part of the policy making framework. And the next point around is then the inevitability of conflict, which arises all the time. How do we go about sort of addressing conflict between competing interests or rights? Human rights law gives us, again, a framework to think about how we can balance those competing interests. And, you know, just recently, Victoria had a case in the Supreme Court regarding the curfew around COVID. And one of the things that I took away from that case was, in fact, the judge acknowledging that human rights is a really useful policy framework for resolving really complex ideas. Okay, so that framework gives us a way to actually balance competing interests and to deliver reasoned and balanced outcomes for all those involved, and in our case, young people as well. And the last point, okay, goes to then beyond the decision. What do we do in terms of raising awareness, informing young people themselves about what's been decided and why, and then of course reviewing, monitoring, evaluating that particular determination to ensure that it's effective, and if necessary, it can be changed as well. So a substantive rights-based approach is much more emboldened than we often see in some of the superficial rhetorical-based approaches. Not easy to do, but in fact, to go back to the key point in that Victorian case, it actually generates better outcomes. And particularly if you're drawing on the expertise of children, you're going to get much more effective outcomes because they, with their lived experiences, can inform what actually matters to them and how we as adults can help develop, I suppose, measures or responses that will assist them, whether it's reproductive health, digital technology, education in school, bullying, discrimination, all those issues we're seeking to address as adults are much more effective when in fact we involve young people in that process as well. So room to be gained there, but things are happening, I think, as well. Okay, so what are the three obstacles that actually impede our ability to actually get to that substantive model? I think I've identified three. There are many more that we can discuss in the conversation. One is this a misunderstanding of the idea of children as rights bearers. So many of you may be aware that back in the late 90s, there was a real big push to actually withdraw from the Convention on the Rights of the Child. We actually had a Senate inquiry, and the inquiry didn't actually embrace the convention, but decided it wouldn't withdraw because that would look bad internationally. So there was no commitment to the idea of children's rights per se. It was largely, well, gee whiz, we've ratified, we shouldn't pull out. That would be a bad look for us on the international stage. But if you read that report, I think it's worth going back to it. Some of the comments that you see, I think, have relevance today, okay? And it's all around this idea that the convention and giving rights to children will undermine, and in fact, not undermine, but destroy parental rights and destroy the contemporary family. Now, certainly a rights-based approach challenges the family structure. It gives much more power to the young people, but it does not give my children the right to determine where they go, what they see, what they eat, what they drink at any point in time in their entire childhood, okay? There's an evolving capacities argument there, and I'm constantly negotiating that as an adult with my children. The twins are 12, Charlie's 15, Grace is now 18. There's been a real understanding for me about what that looks like. So the convention changes that dynamic, but it doesn't completely undermine my responsibility to actually engage in that conversation around how I can also assist in protecting them, but recognizing their evolving capacities. But there's this real sense that it's this really dangerous, deceptive thing that's designed to destroy families. It's not. It's actually designed to assist and enable and support families that are much more deliberative and much more democratic in the way they function as well. But I think that persists. I'm interested to hear what people say, but I think that's one big obstacle because that's very political. If the general population doesn't like the idea of children as rights bearers, that makes it very hard for our governments to pass legislation that would actually entrench the idea of rights, children's rights in our legislative framework and our regular systems as well. The second thing is just how we think about children themselves. And this is a really good study, Australia's attitude towards children from the Valuing Children Initiative. I've been a bit provocative here in the things I've taken out of that, but you know, how important are children really in this country? Ranked 9 out of 10. And then the words used to describe children, if any of you wrote those down at the start of the class, I would be very disappointed in you. Spoiled, fortunate, lazy, selfish, and vulnerable. The last one I'll accept, but the rest of them, no, you can't write that down. Having said that, my twins did pretty well on their birthday today. But you can see here, there's a tension again, isn't it? How we see young people in society. And that makes the challenge for providing recognition of rights more challenging, okay? So in other parts of the world where the status of children might be actually higher, the need to assist them might be greater, then the capacity to use the language of rights may be more accessible. But in Australia, I think we've got some serious issues around A, the idea of what rights mean, and B, our status of children that make it difficult. And that's then tied to the third point, which is lack of awareness, which I think is really critical. And just quoting the National Human Rights Consultation Report back from 2009, the biggest thing that they found then around human rights in general was just lack of awareness, okay? People just don't know about it. And I think the same thing still goes for children's rights, and in fact, is probably even more relevant. I don't think things have changed that dramatically in 10 years. Yes, there's great awareness amongst some people working in this space, but institutionally, socially, culturally, I don't think we have an awareness of the idea that the Convention on the Rights of Child exists, and that it has a really, I think, dynamic, creative way of thinking about how we engage with young people as well. So there's a challenge there for us then, for those who work in this field, to say, well, how can we start raising awareness in a way which actually addresses the misperceptions of the idea of children as rights bearers, and also elevates the status of children and demonstrates the utility of the Convention as a way of moving forward. Okay, so nearly there. So how do we get there? How do we actually get to the point where we see effective protection for children's rights and the Convention as envisaged, all those years ago? I suppose the first thing I want to say is that this takes time, and a long time. Okay, one of my colleagues, Cesar Rodriguez, talks about the idea of geological time when it comes to human rights. We've got to think on a longer time horizon. We can't think it's going to happen in 2 or 5 years. We're talking 10, 20, 30 years. So with 30 years down the track, have we made progress? Unquestionably. Have we got a long way to go? Absolutely. If you read anything in any of those reports I identified at the start of the class, you'll see there are serious deficiencies in Australia when it comes to the protection of children's rights, and in fact, recognition of them as being rights bearers. Better than we were 30 years ago, but a long way to go as well. One of the things I want to highlight, though, is the committee's idea that we need to establish some sort of comprehensive national child rights legislation that actually will fully incorporate the Convention. So let's embed it in our systems of governance that then will affect policy making, service delivery across all sectors in a way whereby we sort of see the Convention being mainstreamed. We haven't got that at all at the moment. We've got piecemeal bits within juvenile justice or youth justice, within child protection, within the Family Law Act, but it's very piecemeal. We haven't got that systemic, integrated recognition of children's rights, which will inform the way we do things. So is this realistic to think that actually might happen? And I'm going to skip forward from the Commissioner's comments to the experience of Scotland, just because I think it's really important to highlight that, because I think in some ways they're at about 10 years ahead of where we might be, maybe 5. But what's happened over there, as many of you will know, is after sort of 10-year sort of advocacy period, okay, the Scottish Government has now committed itself seriously to a revolution in protecting children's rights. They actually use the word revolution in the documentation on their website, which I think is quite extraordinary. So there's a lot of political courage happening there. And there's an agenda which is quite explicit in saying, well, how can we actually progress and realise the human rights of children in Scotland? There's an action plan to achieve that, which I think is extraordinary. I think it's worth reading that document and thinking, well, how can we adopt that federally? Maybe not. Within the state level, some states possibly. Territory level, maybe some territories, perhaps the ACT, is more amenable to this sort of, approach that let's be serious about protecting children's rights. Because if we do it, the evidence says we will all benefit. This is the irony about this model as well. And so for those who don't know much about the actual Scottish approach, they're seeking to literally incorporate the entire convention into Scottish law. I'll let you read that in your own time, but creating as being the foundation, the bedrock upon which all laws, all policies, all service of public authorities is informed. And it's not just 1 or 2 articles. So I think about the Victorian Charter, the Queensland Charter, Bill of Rights, or the ACT Bill of Rights. You might have a little reference to youth justice over here and a bit of a reference to the best interest. This is every single article embedded into domestic law. Significant, revolutionary, clearly possible. It's being debated as we speak. Okay, will it get passed? I hope so. I think people are confident that it will be. What it actually will do then are the things I've outlined in this slide here, taken from the website as well. So as I said, incorporating the entire convention into domestic law with a few little changes to accommodate that transformation, requiring all public authorities to act compatibly with all the rights under the convention, not just a few that we see in our domestic human rights protections, giving significant power to the Children's Commissioner, requiring regular child rights impact assessments, okay, and then reporting as well to evaluate the impact. This is a serious transformation. Is it possible? Clearly, Scotland believes it is, and it's a model worth watching. Can we be inspired by it, and can we follow it? Definitely. But is there political will? That's the real challenge. And I suppose the onus comes back on people like us to say, well, are we prepared to agitate, advocate, and persuade our political leaders that, in fact, this sort of model might have a role to play? When I ask the question of where to from here, this is one model that clearly has been led by adults with children as part of the process. Well, where I finish though, of course, is not with my voice or the Scottish voice, but in fact the voices of our own young people, and particularly our own Indigenous people as well. And many of you have hopefully heard of the Imagination Declaration. If you haven't, make sure you read it. It's quite inspiring. Adopted last year at the Garma Festival by a group of young Indigenous people. You see a young girl here, Sienna Stubbs, 17, reading out the declaration to the members who were at that gathering last year. And I've given you one extract here. And I think this is really significant. We go back to that first question, how do we see children and how do we see Indigenous children? Vulnerable, needed protection, you know, victims of violence, victims of dispossession. Here they're saying, see it in a different way, okay? We want freedom to be whatever a human mind can dream. When you think of an Aboriginal or Torres Strait Islander kid, or in fact any kid, imagine the possible. Don't define us through the lens of disadvantage or label us as limited. Test us, expect the best of us, expect the unexpected, expect us to continue carrying the custodianship, imagination, entrepreneurial spirit and genius. Expect us to be complex, because they are, and let us spread our wings and soar higher than ever before. We call on you and education ministers across the nation to establish an imagination declaration for our Indigenous kids and in fact for all Australian children. And so when I sort of ask the question, are we there yet? We clearly aren't. Can we get there? We clearly can, but that journey must be led by, inspired by, and collaborated with young people themselves. So I'm going to finish rambling on there and open up the opportunity for people to ask questions or give comments. We've covered a fair bit of territory in a pretty short period of time, but I'll stop sharing my screen and I'll go back to the chat. So I might ask Angie to perhaps navigate the chat if there's any questions or issues that people would like to address. You've got a Q&A function as well. I think we can raise questions too.
Excellent. Thank you, John, as well. I think an imagination agenda is for all of our children, including our Indigenous children here in Australia, is certainly one very worthy agenda, and I just love that. I love that language. Thank you. That was just an incredibly insightful overview of where Australia's at. As you say, I love that Simpsons reference. Are we there yet? Are we there yet? Not quite. And, you know, looking at some of those key barriers, including the Australians' attitudes towards children, I think that really gets to that tension, I think, of that interplay between, you know, policy change and attitudinal change. It's got to happen in parallel, and of course, attitude change takes so much longer than the long road also of policy. I have lots of questions, but Holly has asked if she could ask her question in person. So I'm going to try to attempt that technology now, and I will bring Holly up.
That's clever.
Now, Holly, are you there?
I am. Can you hear me?
Yes, we can. Go ahead.
Great. Thanks so much, Angie. I really appreciate it. And thanks so much, John, for such a wonderful presentation. It's really good to see you again.
Likewise, Molly.
Yeah, and thanks so much, Sharon, for offering this forum. I think it's a really important conversation to be having, and one that is so overdue in our political climate at the moment. John, I really agree that there's some very significant advances being made nationally in relation to advancing kids' rights. But generally, it's my view that, as Laura Lundy has recently said, that it's a very chilly environment for children's rights globally. But I think that we've got some really promising developments taking place, particularly in Victoria, and the work of the First Peoples Assembly of Victoria and the enfranchisement of 16 and 17-year-old Aboriginal young people to vote to form that assembly, I think is one of the most significant children's rights advancements in Australia at the moment, and indeed globally. I think this should be noted globally, given the lack of enfranchisement of children across the world, aside from a few jurisdictions. So leaving aside the government's disgraceful and wholesale rejection of the Uluru Statement from the Heart, I'm not really sure about the uptake of the Imagination Declaration. I'm guessing that it's pretty poor. I think both of those statements call for voice, and the call for voice in both of those statements, I think, opens up huge amounts of possibilities for kids and young people in in this country, not only in terms of providing a voice and offering views, but in reshaping Australia's constitutional arrangements, our political arrangements and our legal structures. So I'm just wondering your view, sorry it's a very long question, John, but I'm just wondering your view about whether we should be targeting some of the advances that Aboriginal people are making in Victoria and really focusing our attention on this enormous legal, I think, victory.
So, I mean, you're an expert in this space, Holly, given your PhD and your own research. You're an example of how people are applying a rights-based approach in practice. But I didn't get a chance to speak more generally about what Indigenous communities are doing. But the Koori Youth Council is another group, again, that's doing some really creative stuff around promoting the voices and views of young people, all the work they adopt as well. So what I think we can be doing, we should be doing, is actually celebrating that and promoting that beyond those communities as well. So we can say to other groups in our society, to other groups of young people and our leaders, this model actually works. You know, if you have empowerment of young people and you include them in processes, you actually end up with better results. I was involved on an inquiry around youth detention in Parkville a few years ago when the riots were taking place. And to the government's credit, they actually had consultations with the young people who were in detention. And they all said the same thing. No one listens to us, no one wants to speak to us, no one wants to hear from us. You know, so that disenfranchisement is fundamentally critical in any area, whether it's Indigenous, youth justice. So the more we can celebrate that, demonstrate that, support it through our research, people like yourself, and then show that to other parts of our government system, then I think that becomes the bedrock and the building base on which then look for much more systemic change. It'll take time, but good case studies become very persuasive. And I think it's a really good point to highlight that there's some really good progressive things happening there.
Yeah. Thanks so much, John. Can I just press that just a slight bit more? I'm wondering, do you think that there is room, be it via referendum, which it would need to be, with respect to voice, for specific mention of children and young people? Do you think that's likely? And do you know of any other examples globally where children have been acknowledged in constitutional documents around voice?
Yeah, no, I've got an article. Some constitutions actually embedded in the Constitution. It's like we're a long way behind. So the constitutions adopted in the last 20 or 30 years will have a much greater commitment to human rights in general often, and often explicit commitment to children's rights. I'm happy to sort of give those articles to you. So yes, but will it happen in Australia? Probably unrealistic, to be honest. We can't get anything changed in our Constitution. So that may be a difficult sort of one to push. But we should be, looking to what other jurisdictions are doing for sure to try and at least make the case about recognising young people in a much more effective way.
Thanks, John.
No worries.
Okay, thank you, John. We have Eliza and then we have Sheridan. I'm just going to read Eliza's question out. Eliza asks, just wondering about your thoughts on the ACT Parliamentary Agreement, including the commitment to develop a charter of rights for parents and families involved with the care and protection system and embed this in the Children and Young People's Act. And she follows on, currently our Human Rights Act does not include all economic, social and cultural rights, so particularly interested to know your thoughts on the sequencing of reforms.
Yeah, so it's both good questions. I'm not familiar with what's happening in the ACT on that agreement, other than to say that's not uncommon to development, this idea of having targeted charters of rights. And I think there's actually something in that because some of the commentary in the convention is it's a document adopted at the international level. It's very broad and abstract in its terms. So the idea of tailoring and developing dedicated charters can have a really important role to play in particular context. That makes sense as well. So, if we can't get embedded what we see in the Scottish sort of example, where we have this wholesale importation of the convention, then another way of doing things, of course, at the same time is to be doing these targeted interventions, whether it's around healthcare, out of home care, child protection systems. So clearly there's a really important role to play in that space. And what we're doing now is we're trying to create an acculturation effect, whereby the language of rights becomes the one which we think about child protection, youth justice, digital media, whatever it might be as well, as opposed to welfare. So, you're running two systems here at dual track in terms of advocacy and change. And then in terms of the broader question on economic, social and cultural rights, a really good question to ask. I mean, for me, COVID has highlighted that we clearly in this country believe that health is a right in terms of all intents and purposes, as is education, in fact, as is housing. The Victorian government yesterday allocated $5.5 billion for social housing. And this is again, because it's good. It's good for everyone to actually protect these interests. What we haven't got the courage to do is actually elevate those interests to rights, which then creates much more effective systems of accountability and entitlement on our government. And that's an ongoing debate. But I think this is a really opportune time to be thinking about that, particularly as a result of what's happened in COVID. We've just seen in this country, we don't let people fall through the cracks. Some issues around what's happening with the job seeker payment, of course, as well. But by and large, we as a nation think it's important to allocate resources to support people, access to healthcare, access to housing, and particularly around mental health as well. There's a great awareness. So I think there's opportune times that are coming out of COVID that allow us to be much more strategic in how we think about much broader issues around human rights, but particularly for children as well. I mean, you know, Sharon's expert in child poverty, but the rates have gone up globally for the first time and have no doubt gone up in Australia for the first time in many years, where the curve is bending back up. That can't be happening. So that goes just around those welfare payments. We need to be thinking about how we address social security in ways that protect children and protect families. And certainly all the research suggests that's the most effective way to prevent the need for intervention later on when you have family breakdown caused by poverty in life as well. So not an easy answer, but a really important question, thinking about how we go about addressing those big issues.
Thanks, John. And I think the question here from Sheridan is also related, partly in what you've already answered. Sheridan's asking, how do we raise awareness of the role of the convention and child rights issues more generally, and who should be doing it?
Yeah, so isn't that a really important question? I think
question.
Yeah, I think it requires coalitions. You know, so part of my reasoning for trying to become an academic network amongst academics in this space is to try and be much more effective in how we share and disseminate our research around issues that concern children. And then, of course, people who work in the advocacy space, civil society, being much more collaborative as well. I think there's a really good group in Australia, the Australian Child Rights Task Force, does a really good job of doing this internationally. The challenge, of course, is to do it locally. One of the gaps is knowledge of what some of the rights-based approaches require in certain jurisdictions, in certain areas, you know, whether it's child protection, or whether it's, as I said, social media or youth justice or education. So I think there's an obligation on people like myself, to be honest, to raise great awareness around that, and then be thinking, well, how do we target and how do we identify, you know, politicians or policymakers or service providers who are open to these conversations. As I said, early childhood educators are really open to rights-based approaches to early childhood. As a collective, they have embraced it. People in the education department in Victoria have embraced it, and they're trying to use that. And clearly it's not perfect, but that's an example of where you can persuade people that this model actually does work. So it requires a lot of collaboration and a bit of strategic planning. But I think, as I said, overseas, it's much more effective, perhaps because there's more people working in this space here. But we can address that. It just takes a bit of collaboration as well to work with each other, work out most effective policies. The youth strategy being developed in Victoria, I think is a really good opportunity. So if any of you are in Victoria, even if it's a state, you know, the more submissions that talk about this idea of a much broader rights-based approach and the obligations it imposes on government in a holistic sense, I think it's a good opportunity to raise that and flag that as well in Victoria. I'm not sure that answers the question because it's a difficult one, but conversations have to keep going.
Great. Thanks, John. And this is probably our last one, unless someone wants to jump in with 6 minutes to go and many celebrations today. I've also got my eldest has turned 10 today, so we've got to get on and with all our birthday celebrations. This is from Sharon, and it's a follow-up on the ACT developments around a Charter of Rights for parents and families. The ACT has had a Charter of Rights for children in out-of-home care since 2009. Sharon says, in an ideal world, targeted charters would be highly complementary, but in reality, there are sometimes tensions. So how do we deal with possible tensions that might arise from a series of targeted charters?
Yeah, so good question again. And there's always a risk that a targeted charter will actually not be consistent with what I might say, you might say the convention requires. I mean, in some respects, this becomes a question between universalism and, you know, local interpretations of what might be relevant for community. The key thing is the process we use to develop these charters as well. So, you know, if the charter is developed in a way which doesn't accommodate children's views or actors that should have been included in that process, then clearly we want to that could be a source of the tension. We want to actually try and reconcile that. But I think most of these things are about dialogue, really, and then who we involve within the conversations, which goes back to my point about a substantive rights-based approach. Once we conceptualize the issues, what policies and processes do we use to try and address those issues? And if it's a collaborative, participatory-based approach, then, you know, it may be that that's the most appropriate particular charter or document for that particular community. But you still keep reviewing it and evaluating. And that's the key point of the rights-based approach. Things shouldn't be static. They should be reviewed and evaluated on an ongoing basis to ensure they are actually achieving their underlying objectives, which should be informed in theory by the convention as well. So I'm not sure that answers your question or avoids it, but I think it's important to point out there can be tensions. The question becomes, what was the process that led to it, and how do we seek to reconcile it if we can?
Great, thanks, John. And I think this is probably our last and final question. I can see people have warmed up in the chat there now, but this I think will have to be our last. Sure. And this is from Neema, who finished her master's here at Crawford last year, could be this year. Sorry, Neema. Our years are melding into one. Fantastic presentation. Thank you, John. Where do you see Australia's heading to on child rights to have a good environment, observing that there is even more degraded environment and more visible climate stresses?
Yeah, so isn't this the important question? You know, in some way, I took some slides out of Greta Thunberg. What we're seeing happening globally, in fact, is that young people are leading this race to actually address climate change. So the old folk like me, who are bogged down in marking, aren't really doing enough. But young people themselves, I think, are saying, if adults can't take control, then we will. And I think then what we need to be doing is supporting that, to be honest, and agitating and advocating for them and scaffolding them to be able to take that lead rather than saying, oh, you should be doing this, that, and the other thing, you know, having a welfare-based approach. So I'm actually really heartened when I see young people say, we've had enough. When they lodge complaints under the Queensland Human Rights Act, when they start proceedings before the Committee on the Rights of the Child, when they advocate in the world stage around climate change, it gives me great hope that, in fact, the faith I have in young people is being, you know, is being demonstrated as being real. And I think the obligation for us is to enable it to happen as best we can, because they are the ones that will be inheriting what we've made of this world. And I think they will have the capacity, and go back to the imagination, they have the genius, the entrepreneurial spirit to recreate systems or manage our lands, our seas and our skies. So, you know, I think for us as adults, let's help them do that rather than make it harder. Yeah,
I think that's just a fantastic point to end on. Thank you so much, John, for your time. I know you've got all those birthday celebrations to go and prepare.
A lovely day, so, exactly, that's right.
Again, thank you so much from all of us. That was a fantastic overview and a great discussion. If anyone would like to get in touch, in terms of joining John's academic network, or if you would like to come and present with us here at the Crawford School, then please do get in touch. Thank you so much, everyone.